Hi friends, we have covered 3 episodes on various frauds related to insurance claims. Frauds are there in motor third party claims as well. However, under motor third party claims, insurance companies are in a little disadvantage because the accidents giving rise to the third party claim would have been already investigated by the police, charge sheet filed, and accused convicted, and the awards are being given by the MSCT courts. Therefore, correcting a wrong investigation is practically very difficult. Of course, after collecting sufficient evidence, requests can be made with the police authorities for reinvestigation. The usual frauds we come across are that of changing the vehicle and the driver. This happens when the vehicle that has met with the accident is not having insurance cover. Usually it happens with regard to two-wheelers. Another vehicle is shown as the accident causing vehicle. Of course, there is a difficulty. The post-accident formality of motor vehicle inspector inspecting the damaged vehicle is a restraint for this type of fraud. However, some smart people manage this by changing simply the number plate, where the officer is either negligent or obliging. They manage with their fraud. The question of changing the driver arises when the driver at the wheels at the material time of accident was not having driving license or not licensed to drive that particular class of vehicle. As the punishment usually awarded for road accidents are known and not that hard, there may be obliging people to appear as the accused and pay the fine. These problems got manifested mostly after the computerization of records. Insurance companies capture the vehicle number as well as the name of the driver causing accident, and on routine run the check of multiple accidents as well as accidents causing vehicles as well as multiple accidents causing drivers. It was incidentally noticed that in a particular city, one person has caused almost 16 accidents. Obviously, that was a foul play. A detailed investigation was carried out and complaints were made with the appropriate authority. Similarly, multiple accidents causing vehicle were also noticed after the computerization. The facilities offered by the computerization, information technology has opened up this sort of frauds and to some extent enabled the insurance companies to control such frauds. Another type of fraud is making non-accident related injuries, motor vehicle accident related injuries, and filing claim under MSCT. Usually, it is difficult to trace such cases. However, while studying the file, the officers may get a feeling, get a doubt leading to detecting such frauds. One such case was where the victim was treated in a hospital which was almost 16 kilometers away, far off from the stated place of accident. The injuries suffered by the victim were serious in nature. Therefore, a thought occurred in the mind of the officer that the victim should have been admitted to a nearby hospital instead of 16 kilometers far off. And there was also a time lag between the date and time of accident to the date and time of filing of FIR. The fraudsters need a little time to manage things. So, a detailed investigation was arranged. It was found out that the injuries were suffered in a clash between two criminal gangs. It was actually happened somewhere near the hospital where the victim was treated, and other persons injured in the clash were also treated in the same hospital. And the police in that jurisdiction refused to oblige to the fraudulent intentions of the victim. A police officer, police station which was 16 kilometers away was prevailed upon to register the case as a motor vehicle accident occurred in their locality. This is one type of fraud usually played in motor third party injuries. Another incident I remember was in respect of a scooterist. Scooterist used to work in the nearby city and used to go home late in the night, almost past midnight. On that fateful day, he lost control of the scooter, of the two-wheeler. It went and hit against an electric post, causing severe injuries to him. Multiple surgeries were required to set right the fractured leg of the victim. Somebody gave him advice, make it a road accident claim so that he can at least get some compensation. Another two-wheeler was brought in. A story was concocted saying that the accused rider has come from behind and hit the victim. Victim lost control and went and hit against the electric post and suffered injuries. The officer studying the file got a doubt. Doubt was only simple. It was midnight. The presence of the victim at that point was established by the statement given to the police. But usually at that time of the night, nobody will venture out in a two-wheeler unless there is a specific reason. There was no specific explanation, reason given by the accused rider in the statements given to the police. So he felt something fishy. An investigator was engaged for a detailed investigation. He visited the site and met the nearby house people, neighbors. None of them were remembering about the involvement of a second vehicle in the accident. Then he went to the address of the accused. It was almost 25 kilometers away from the accident spot. That also has given rise to the doubt, suspicion. And when he went to the place to meet the accused driver, he had already admitted guilt and paid the penalty imposed by the court. He found out to his astonishment that he was a distant relative of the accident victim claimant. His further enquiries revealed that the entire story was concocted so as to make it a motor accident and file a claim against the other vehicle rider, of course with his connivance, and get some compensation. In such cases, the option available with the insurance companies are to file appeal before the highest police authorities for arranging re-investigation of the case. Sometimes it brings a positive result, sometimes no. Let us hope that public awareness will act as a deterrent and such frauds will be eliminated from the society in due course. See you. Bye.